Good afternoon. I'm Michelle Levander, Director of the Center for Health Journalism. Thanks for joining us today for our Health Matters webinar, Will Obamacare Survive the Latest Trump Maneuver? This webinar is offered thanks to generous grants from the Commonwealth Fund and the National Institute for Healthcare Management, the National Institute of Healthcare Management Foundation. The U.S. Department of Justice is supporting a legal effort by 20 Republican-led states to upend the Affordable Care Act's core provisions. The lawsuit argues that the individual mandate is unconstitutional and that the law's promise of coverage to people with pre-existing conditions must be overturned. On the other side, California and 16 other liberal states are fighting to preserve the ACA. In this webinar, we'll be asking some fundamental questions. Should this case against the ACA prevail? Does it spell the end of health reform? And will this fresh legal uncertainty lead to higher insurance premiums for Americans or more insurers fleeing already fragile exchange markets? Here to help us understand all this, we have two distinguished speakers. Timothy Jost is an emeritus professor of law at the Washington and Lee University School of Law and a leading health policy expert. He is co-author of the casebook Health Law and several other books, and he routinely writes for the policy journal Health Affairs. Stephanie Armour is the health policy reporter at the Wall Street Journal, where she covers the Affordable Care Act, Medicaid, congressional health legislation, the opioid epidemic, and state health initiatives. A reporter for more than 2 decades, she has produced award-winning investigative projects on subjects including food safety, body brokering, and human trafficking. Before we get started, I wanted to share a few operating procedures. We'll hear first from all of our speakers, then we'll open it up to your questions for the final 20 minutes. Because we have several hundred people participating in the webinar, we'll ask you to comment in the question field in your control panel, and we'll read out your questions. If you have technical challenges, please also text us through the question or comment field in your control panel. You can tweet about this webinar at #ACALimbo. So Tim, get us started here. Help us understand these dramatic developments that we're seeing and what they're going to mean for Americans.
Thanks, and thanks for inviting me here today. Can we have the first slide? I'm not seeing the slides. Are they up?
Yeah.
Okay, well, I guess my connection isn't working. Anyway, on June 7th, 2018, the Trump administration's Department of Justice dropped a bombshell in a rural Texas federal courthouse. The administration filed a brief stating that it would not defend 3 key provisions of the Affordable Care Act. If the judge presiding over the case agrees with the Trump administration, millions of Americans with pre-existing conditions could face denial of coverage or higher premiums. The brief was filed in Texas versus Azar, a case brought in February by Texas and 19 other Republican-led states. Texas had asked the court to declare the provision of the ACA requiring individuals to have health insurance unconstitutional. It argued that the Supreme Court had held that the mandate was unconstitutional in 2012 as a legal command under the Commerce Power, but upheld it as a tax. When the 2017 tax Texas argues, and thus entirely unconstitutional. Texas argues further that the individual mandate is essential to the operation of all of the other provisions of the ACA, and thus the entire ACA should be invalidated. In early April, California and 16 other Democratic states moved to intervene in the lawsuit to defend the ACA, and that motion was granted in mid-May. On April 26, 2018, Texas and the other plaintiff states, joined by 2 individual plaintiffs, asked the court to enter a preliminary injunction invalidating the ACA. Next slide. On June 7th, California and the other states with Democratic attorneys general filed their response to the preliminary injunction motion. California argued that the individual responsibility provision, though no longer enforceable as of 2019, remains constitutional. It argued further that Congress had no intention to repeal the rest of the law when it eliminated the individual mandate penalty in 2017 for 2019. As a result, the entire remainder of the ACA must be upheld, even if the court finds the mandate unconstitutional. These arguments were expected and indeed obvious. The big surprise was the Justice Department brief, also filed on June 7th. The Justice Department took the side of Texas, agreeing that the mandate is now unconstitutional. The Trump administration also argued that the ACA's guaranteed issue and community rating requirements, which ban insurers from denying coverage and charging people more based on their health, can only work in tandem with the mandate and thus must also be invalidated. The rest of the ACA can function without the mandate, the Justice Department said, and should be retained. It appears that the Justice Department initially intended to defend the ACA entirely. I believe that the department switched sides at the last moment based on a decision made at the highest level. One indication of this is that 3 career Justice Department attorneys withdrew from representing the United States at the last moment immediately before filing the brief, apparently unwilling to sign their names to a legally questionable brief, and one very senior attorney resigned shortly thereafter. Another thing that indicates that this was a position taken at the last moment is how sloppily the brief is written. It's not even clear from the brief exactly which provisions of the ACA the administration is unwilling to defend. Next slide. The basis of the DOJ argument is that without the mandate, community rating and guaranteed issue must be invalidated under a doctrine known as severability. The court invalidates a statutory provision as unconstitutional. It must consider the other parts of the statute and whether they can be severed from it. And this is basically a question of congressional intent. Can the remaining provisions of the law function without the unconstitutional provision, and would Congress have wanted them to do so? The Justice Department brief argues, as did Texas, that the ACA, as adopted in 2010, contained congressional findings that the individual mandate was essential to creating health insurance markets in which the ACA's market reforms would work, and thus congressional intent is clear. Course, that the individual mandate was constitutional, a position upheld by the Supreme Court in 2012. The ACA's findings section, however, links the mandate not to guaranteed issue and community rating, but to community rating and a provision banning pre-existing condition exclusions. The Justice Department cites 3 ACA sections as guaranteed issue provisions and 2 as community rating provisions that it will not defend. One of these is the provision prohibiting pre-existing condition exclusions, but the brief scarcely mentions pre-existing conditions. In fact, the real question for purposes of severability, as a number of the briefs on the other side pointed out, is not what Congress said or did in 2010, but what it did in 2017 when it passed the tax bill. Texas does not argue that the individual responsibility requirement as adopted in 2010 was invalid. It did argue that before the Supreme Court and lost in 2012. Rather, it argues that now the 2017 tax bill made it illegal. So the real question is, what did Congress intend in 2017? One thing that I think is perfectly clear to anyone who followed the 2017 repeal debates is that Congress did not intend to get rid of protections for people with pre-existing conditions. Indeed, both Senators McConnell and Alexander, the Senate Majority Leader and the chair of the Senate Health Committee, have said in the last week that no one in the Senate meant to get rid of the pre-existing condition protections when they voted for the tax bill. By not talking about pre-existing condition protections, the Trump administration may want to avoid calling attention to the fact that it is in fact trying to get rid of that provision. But Texas and the DOJ clearly call for reinstating pre-existing condition exclusions and eliminating current protections. Next slide. What happens next in the litigation? Last Thursday, 11 amicus briefs were filed in support of protecting the ACA. Briefs were filed by the AMA and other physician organizations, the American Hospital Association, Federation of American Hospitals and Catholic Hospital Associations, AHIP, which represents insurers, the SEIU, which represents 2 million healthcare workers, the AARP, speaking for older people, the American Cancer Society, the Heart Association, the Diabetes Association, the Muscular Sclerosis Association, Families USA and Consumer Advocates, a group of health economists, a group of public health experts, Small Business Majority representing small businesses, and a law professor's brief specifically addressing the question of severability. Only one amicus was filed supporting Texas compared to these 11 defending the ACA, and that brief was filed by Citizens United and a few anti-big government and pro-gun groups. The briefs show unanimous opposition by those most directly affected by the ACA to invalidating the law. Most of the briefs address specifically the impact of invalidating the ACA on members or constituents of the groups that filed. A few, however, addressed more briefly the legal issue, more deeply the legal issues in the case. Particularly interesting was a brief filed by 5 law professors who had been agree that if the judge finds the mandate unconstitutional, he should consider what Congress intended to do in 2017 when it zeroed out the mandate, and thus not invalidate any other part of the law. Next slide. Texas can file a responsive brief by July 9th. At that point, Judge O'Connor could schedule an oral argument, or he could just decide the case on the briefs. Judge O'Connor was handpicked by Texas as the judge to handle this case, and in the past has been very willing, indeed eager, to enjoin ACA regulations. Even though I, and I think most other legal experts, believe that this case borders on being frivolous, I think there is a good chance that Judge O'Connor will rule for Texas. I think it almost inconceivable that he would hold the entire ACA invalid, which is what Texas requests, as this would plunge our healthcare system into chaos. This is particularly true that now the Trump administration has given him an opportunity to deal a serious blow to the ACA without disrupting Medicare and Medicaid coverage. If he issues an injunction, it would not be effective until 2019, since the penalty does not go away until then. The Department of Justice has asked that he issue a declaratory judgment rather than an injunction, since an immediate injunction is not possible. A declaratory judgment would have the same effect, however, as a preliminary injunction as of next year. If Judge O'Connor does rule for Texas, or either party could appeal his decision to the Fifth Circuit. The Fifth Circuit is one of the most conservative appellate courts in the country. Only 5 of its 15 active judges are Democratic appointees, and 4 have been appointed by President Trump. It is therefore conceivable that it could uphold an injunction. This could take a year or more, although it could possibly move faster. Presumably, any order would be stayed during the appeal. Then it would be up to the Supreme Court, which surely does not welcome another ACA case. Of course, we don't know who will be on the Supreme Court a year from now, or how many new judges, or even old, and how new judges or even old judges would rule. Next slide. What would the ramifications be of an injunction? First, Americans with pre-existing conditions would again face higher premiums, pre-existing condition exclusions, and the possibility of coverage denials. Depending on how pre-existing conditions are defined, 50 to 130 million Americans have pre-existing conditions such as diabetes or arthritis. Most Americans under age 65 with pre-existing conditions have employer coverage or Medicaid. The provisions identified by the Department of Justice to be invalidated apply to both the individual and employer group insurance markets. If they were invalidated, however, the provisions of the Health Insurance Portability and Accountability Act from 1996 governing the group market, which were superseded but not invalidated by the ACA, would come back into place. These provisions would ban health status underwriting within employer groups, but would allow pre-existing condition exclusions for employers for up to a year for employees who do not keep continuous coverage. But people with employer coverage would face loss of pre-existing condition coverage if they lost or left their jobs. Group the individual market, but did not assure them affordable coverage. People would once again be locked into their current job and barred from launching their own business or moving into the gig economy. People with Medicaid coverage and pre-existing conditions would also have to be careful not to earn too much money and thus be pushed into the individual market where coverage may not be available. It should be noted that 15 states have statutes banning health status underwriting and pre-existing condition exclusions. 5 more have statutes banning some of these practices, and 3 more have regulations to similar effect. These statutes or regulations, however, would not apply to self-insured employer plans, and each state's law would have to be analyzed to determine its effect on particular situations. It should also be noted that sections that the DOJ would invalidate ban not only health status underwriting, but underwriting based on gender, occupation, or other individual characteristics. Age rating would no longer be limited to 3-to-1. Premiums for older men and for women would skyrocket. Next slide. There could also be run-on effects for other provisions of the ACA. It's difficult to understand how the premium tax credits would work in the absence of guaranteed issue and community rating. Premium tax credits are set based on the second lowest cost silver plan. If every insurer can set its premiums based on the health status of every individual applicant, it's hard to see how the second lowest cost plan could be identified, at least not without extensive reprogramming of the entire system, which could not be done by 2019. 10 to 12 million Americans could lose premium tax credits. Moreover, insurers could refuse to insure some individuals altogether, blocking them from getting tax credits. And even if a way could be figured out to pay tax credits, it would be easy for insurers to manipulate it to maximize profit for federal tax subsidies while denying coverage to sick people. Rescissions would also likely again become common. Even if rescissions would remain limited to intentional misrepresentations, once health questionnaires again became standard, we would see insurers offering coverage, but then doing post-claims underwriting and rescinding it once big claims were filed, pointing to something in the application suggesting a pre-existing condition. And of course, if millions of people lose coverage, healthcare providers will face sharply increased uncompensated care bills. Last slide. For all the chaos this case would cause, I see a decision this summer as having few immediate effects. It will undoubtedly add to the confusion that consumers are experiencing, as well as to the anxiety of people with pre-existing conditions, but I don't see how insurers can reasonably respond at this point, other by staying the course for 2019 rates based on what they know. As of July 9, when the Texas last brief is due, insurers will have filed individual market rates in 39 states. But some insurers may drop out of the market altogether rather than dealing with the uncertainty. This assumes, of course, however, that the Trump administration continues to enforce the law as written, even if it believes that it is in part invalid. The administration is reportedly still negotiating with will permit this, and it could do so any day now. This could open the door to other states not enforcing the ACA, which would lead to more immediate chaos and uncertainty. I expect that the real agenda of the Trump administration here, however, is to force back on the congressional agenda repeal efforts, probably something like the Graham-Cassidy bill. If the litigation is successful, it might force Congress to reopen debate on ACA repeal, although it is by no means certain how that debate would end, particularly heading into the midterm elections this fall and given possible changes in the House that those elections may bring. So thank you very much for your attention, and I look forward to hearing what Stephanie has to say and then answering some questions.
Tim, we're going to just maybe ask you a couple of additional questions out of your presentation. One is about something you touched on earlier, which is the amicus briefs from such a large number of organizations and such a wide range of organizations, and a really diverse mix of conservative and liberal organizations, health insurers, and so on. And I'm wondering, what does this mean philosophically about where we are as a country? On the one hand, we have this effort to completely, remove the last pillars of the ACA, and then we have what seems to be a fairly extraordinary turnaround if you look back at who was opposing the ACA when Obama was first getting underway, and what happened with the Clintons with their earlier efforts. So I would be very interested in your thinking on that.
Yeah, well, I mean, the people who filed these amicus briefs were, stakeholders in the healthcare system. And at the time that the ACA was passed, it had fairly widespread support from stakeholders, from the hospital associations, from the medical associations. Did not immediately have support from the insurers, so they have definitely been brought on board. But I think what the briefs demonstrated was that really everybody who has a stake in our current healthcare system, including doctors, hospitals, insurers, patients, consumer groups, businesses, everybody now has a stake in the Affordable Care Act because it is so irrevocably woven into our healthcare system. The small business majority brief was interesting because it talked about how many self-employed people and owners of small businesses are now insured under the Affordable Care Act. And it has made a huge difference. I mean, small businesses were just simply dropping out of the health insurance markets. So I think what it does demonstrate now, there really weren't any ideologically conservative groups that filed briefs in support, and some of the consumer groups have a long-time reputation for supporting the ACA. But I think what the brief does show is just that support now is almost universal across our healthcare system by people who are really affected by the ACA.
This is really covered as a kind of political story, separate, or in this case, a legal story, sort of separate from the lives of people. So if you were going to advise reporters who are writing from either a regional perspective or a state or local perspective on this, what are some of the other implications we're seeing, maybe even with the midterms or beyond, that you would advise them to look at from outside of the Beltway?
Well, I mean, certainly from a political perspective, I think at least a couple of the attorneys general who signed on to this brief are running for higher office. So I think, an interesting issue for them is, and I'm sure an issue that will be raised repeatedly in the campaigns, are, do you really want to get rid of the Affordable Care Act entirely, which is what the Texas and the other states are asking for? And if so, is that what your constituents really want? So I think there's a political question there. There are certainly questions as to how this affects individuals. And most obviously, those are individuals who are in the individual health insurance market and who are buying their health insurance and who are, quite frankly, going to see in many states huge increases this year because of the repeal of the individual mandate and because we expect very shortly, perhaps this afternoon, administration proposals that would allow association health plans, and in the next month or two, probably proposals that would allow short-term limited duration plans to be marketed completely outside of the Affordable Care Act protections. And I think there's a real concern on the part of insurers that healthy people are going to flee the insurance market for those plans and leave people with high healthcare costs behind, and that will drive up insurance premiums dramatically. And certainly that's what the insurers are thinking right now, and that's what they're thinking as they're setting their rates for 2019. So I think you could certainly find people who are in the individual market who are going to be affected by those higher rates, who have pre-existing conditions. But also, as I said in my talk, the pre-existing condition exclusions also affect people who have employer-covered insurance. Now, most of them would be protected under HIPAA immediately through their current insurance, if they've been there for a year or more, if the pre-existing condition protections are gone. But they wouldn't be able to leave their jobs to retire early, to start out on their own, or even if they become sick and have to quit their job. So I think people are aware of that, and I think this is something that affects probably every reader or listener or viewer of every reporter on the line.
Thank you, Tim. And that's the perfect segue to Stephanie Armour. We're going to ask you to talk a little bit about what your strategies have been in reporting this and some of the advice that you have for journalists all over the country.
Great. Thank you so much. I'm hoping you can hear me okay. I had a little bit of technology trouble, but so there may be some newsroom back. And if I remember at the time, despite all the attention it's getting now, when it first came out, it basically did not generate much interest at all. A lot of the individuals that I spoke to were pretty dismissive, saying this was frivolous and a reach, which, they're still saying now, but I think at the time they kind of thought that this was more of a nuisance than a real issue that was going to gain traction. The reason I did a story and what struck me as especially interesting is that a lot of this was being led by the Texas Attorney General, Ken Paxton. And for people, if you know, he's kind of been one of the leaders in this pioneer of attorney generals who are increasingly becoming activists. It used to be a relatively kind of stepping stone position. And, he got a primary endorsement from President Donald Trump. He also had brought the lawsuit against HHS's non-discrimination policy on transgender. So he's someone who is worth watching in terms of the battles that he's waged against the Affordable Care Act. So even though kind of there was the sense that this wasn't going to be a big deal necessarily, or that was very frivolous, there was also the sense that it had some potential. And I kind of think, in the reporting world, I think that the kind of threat to the ACA almost came up from behind the scenes to some extent. And I think part of that is simply bandwidth. There's been so much attention focused on right now to changes to Medicaid, the administration's regulatory rollback of the ACA. So it's kind of taken people a little bit by surprise. Not a lot of story back in, when was it? I think maybe it was in May when the 16 at the time Democratic attorney generals filed in the case, led by the California attorney general. There were a couple stories I, frankly, did not do one. I think I was too busy. And there wasn't a lot written back in May when the court did allow them to intervene in the case. And what's really interesting to me from a reporter perspective is you could sort of argue that some of that lack of attention makes a lot of sense. Even the very conservative legal scholars that I've spoken to at like Heritage have really questioned the legal underpinnings of this case and whether it's getting too much attention. It's a fair question. But there was one analyst who actually, this was really interesting, put out this report saying that they kind of thought all the reporting around this was a lot of fear mongering. I don't think that's the case. I think it does deserve attention. I have learned too many times that, the issues that we think are dead come back again with the ACA. So the attention it garnered was pretty quiet at the time, but I think if you'll look at the next slide, which is when the Department of Justice made its decision or put its decision in not to defend the ACA. That was really striking. I had just come back from a going away party for a colleague, and it was, I think, like 7 at night when I saw that this had happened. And it may even have been Jost and his kindness that alerted me, if I remember right. And, so a lot of reporters were taken off guard. Another reporter, literally that I talked to ran into a coffee shop wet from swimming to pound out their story. It was a long night. If I remember right, the editing went till midnight. And it really ratcheted up interest in healthcare again, beyond even just this legal case. Suddenly, we generally hear is that the interesting thing is that even people who typically have been very supportive of trying to overturn the ACA, like Jonathan Adler, who helped build the argument in King v. Burwell, sort of have sided with more liberal legal professors such as Nicholas Bailey, and just saying that they don't think there's a lot of meat here to this case in terms of its legitimacy. But, frankly, it doesn't really matter. The California Attorney General, in a call late last week, said he thinks the case could go to the Supreme Court. And, frankly, I think he's right. And what that means for Democrats and the public is an alarm. Repeal has kind of come back from the dead so many times that Democrats kind of have their radar out for anything that could pose a threat. So it's unclear really how strong the risk is, but the threat is real. And I think it's really made healthcare much more center stage in the midterm elections, at the state level, and in kind of the public discourse. And if you want to go to the next slide. The next slide on this, I think, is a story. This is a story I had done on kind of what this means for the November midterm campaigns. And even though I've done the story, it's frankly a story that is very much still alive and could probably be done repeatedly, because this case for both parties has I think, a significant implication in federal races, in state races, and for state and local reporters. There are a lot of ways to turn this issue into a local or state politics story, or even really a real people story. For Democrats, it's pretty clear what the impact is, although there are still a lot of questions. I have done a lot of stories about the Democratic message going into the midterms, and the strong message, or what they are trying to relay to constituents, is twofold. One, it's that Republicans want to take healthcare and entitlement away. Like, that's one of the big messages of Democrats. The second message is, and this is a little more challenging, is some Democrats really want to fix the ACA, or fix what they see as problems in the ACA. They want to see a stability plan put together, and that is an element of what they're running on. But increasingly, you're also seeing Democrats who want to go a lot further and push like Medicare for all as a stepping stone to single payer. So the threat of this litigation for Democrats has really been a bonanza. Like, this gives them more ammunition right now to portray Republicans as out to steal healthcare, and more ammunition for them to say the ACA is under attack, whether it be the repeal of the individual mandate, which is kind of a catalyst for this last year, or whether it be, as Jost referred to, the association health plan rule, which we're expecting pretty soon. All of these things have kind of eroded the foundations of the ACA. And Democrats that I've talked to, and Democratic Hill staff that I've talked to, say that they're hoping that the lawsuit and the DOJ brief in this will drum up voter turnout, which is really key to them for kind of their hope of a blue wave. So I think for Democrats, it's largely been seen as a bit of a gift, at least from the Democrats I'm talking to. I mean, I also think there's a risk in here, because I think that the increasing talk about healthcare may also potentially lead to Republicans wanting to attention to some of the things that Republicans want to do. It's also given Democrats an opportunity to really use each premium rate request and hike that comes out as a springboard to bring up the lawsuit and say, look, this is a further example of what could happen to premiums. Consumers will start getting the notices of their rates, I think a lot of them in October or so, which is just before the midterms in November. So for Democrats, the timing couldn't be better. In fact, we did a poll here, which I have to admit, it even surprised the editors here, because it showed that for voters out there, healthcare was a top issue, even over the economy and gun control. So you can see that this really is going to be an issue that Democrats are running with. And for Republicans, this has been, the best way to put it is a challenge. Their campaign message has been really pretty simple. Talk about anything else besides healthcare. They don't want voters to be reminded of their 8-year pledge to repeal the ACA, and that they failed late last year in the Senate. And they've wanted to very much focus on other things that they see as accomplishments, like their tax overhaul, things they're doing on opioid right now, any immigration stuff. So the Republicans that I've talked to have said, this is not something we want to have to deal with. And you're also seeing them really come out strongly, at least in their statements, saying they want to protect pre-existing conditions, including Senate Majority Leader Mitch McConnell. There is a smaller minority of conservatives that seem to be kind of cheering the effort on. It was interesting to see, and Jost may have mentioned this, that some of the amicus briefs in the case that were recently filed were very interesting. They were, the gun owners lobby and Citizens United, who were for the lawsuit going up against, hospitals and AHIP. But I think that the one interesting point that reporters can't lose sight of, I think, is that the DOJ brief and this lawsuit also reflects a real rift right now going on in the Republican Party. And this is also playing out in the states between moderate Republicans who really want to focus on other things like tax overhaul and move on from healthcare, and more conservative Republicans who really want to have another go at repeal because they see now as their last chance. Should one of should the House or Senate flip. So this put moderate Republicans in a really tough spot. I think one thing reporters need to watch for is whether, the lawsuit and renewed interest in healthcare will spur some kind of legislative action by the end of August. Ron Johnson may introduce repeal legislation, possible. He's spoken out in support. Democrats like Senator Patty Murray are urging, once again, bipartisan efforts on stabilization and pre-existing conditions. So I guess the big question is, does the attention and potential threat of the lawsuit, along with the rising premiums, put enough pressure on lawmakers that they do make some kind of legislative push? I think it's possible, but reading the tea leaves right now, it's kind of hard to be sure. You can go to the next slide. The other issue is, I think there are just a ton of ways that reporters can sort of pivot off this national news at the national, local, and could do stories on really in any state. For example, people could call up their insurers in their state that are on the ACA exchange and the state regulator and ask, how are they dealing with this lawsuit? Are they potentially preparing any alternative rate ideas? The rate filing process is going on right now, and some commissioners are more willing to talk than others just about their concern. The insurers are submitting filings that detail kind of their plans to participate in the ACA marketplaces. The filings also include information on the premiums that insurers plan to charge next year. So you would really reach out to insurers and say how much of this is factoring into your decision to participate or your premium prices, especially if you consider the repeal of the mandate and some other uncertainty in the market. You can also, I think, a really good story is to explain to readers, should the DOJ prevail, what implications that may have for the state. And I don't think that is necessarily fear-mongering at all, because I think that it's a helpful reminder for people, because a lot of people have forgotten sort of what the rules were, and every state had different rules and were different ways that carriers were restrictive in their underwriting. And it could be very interesting to find out what sort of pre-existing rules were there that limited access to plans. Like, if you read the list, it's really interesting. It's everything from asthma, bipolar, cancer, anemia, anxiety, obesity, dialysis, depression. And one thing I think would be really interesting is talking to some people with pre-existing conditions to find out what their level of concern is. I actually got an email from one reader who said that she was looking at getting some medical attention and medical treatment done now because she was concerned enough about the potential implications of this lawsuit. So it shows that it is having an effect, even if it's in just the concern factor for people. Next slide, if you want. For insurers and state regulators, I think reporters can also ask about what protections do exist for people with pre-existing conditions who have an ACA plan now. Guaranteed renewability is a feature in insurance that obligates an insurer to continue coverage as long as premiums are paid. One of the issues that our insurance reporter was wondering about is sort of how would that guaranteed renewability play out should the provisions that the DOJ wants struck down go into place. Could people hold on to their plans? Could they be kicked out? Could premium prices be increased on them? It's a question that we were wondering about. It is a story that is certainly something that's doable right now. In the Denver Post, John Ingold on the 14th had a really interesting story about a law that was passed years ago in Colorado that enshrines protections for pre-existing conditions, even should the DOJ's brief and request to the court be granted. So I think it's really interesting. If you talk to lawmakers right now at the state level, are they considering looking at any potential legislation at some point that would protect people should this be granted? And I think it also reflects sort of the priority that is now being put on pre-existing conditions. This is not protections or providing coverage. And that's something that could certainly be explored, I think, at the state or local level. It's also possible to reach out to state regulators. This may be something where you'll get more access, quite frankly, in blue states to find out how they're dealing with sort of the threat that's out there. Are they taking any steps? Is this something on their radar? You can go to the next slide. Other questions that reporters can ask would be if they could talk to insurers in their state that provide individual policies to find out if they support the DOJ request, and what would they do if it happens. I think that's a great question to be asking, like what would insurers do in the potentiality of something. Again, are insurers looking at reconsidering exchange participation? This could be more of a significant issue in some of the areas and states that have low participation, one or maybe two carriers participating. The other interesting question is under the pre-existing, people have already been in these ACA plans for a long time now, and the insurers have been paying claims on this, so they already have a lot of information about how expensive certain consumers are. And so one question would be, how could that potentially play out in a state should the DOJ prevail in terms of underwriting if some of the pre-ACA environment comes back again? Another interesting question, I think, is sort of the politics in your state or your election. How is the state attorney general support or lack of support in this case playing out when it comes to campaign races? You look at Wisconsin, for example. The Democratic candidate there for Attorney General has already been slamming the Wisconsin AG for being a part of the lawsuit. And, accusing the Attorney General of using the lawsuit to raise money for his reelection campaign. And the two of them will go head to head in November 6th. So you see this is already becoming an issue in Wisconsin. Members of the public have held protests in Missouri outside of the office of the Attorney General because they're opposed to their support for the lawsuit. You see this is something that's already coming up in Minnesota in the Attorney General race. You're also seeing it in Florida. I think Rick Scott so far has not said directly whether he supports the Trump administration on this. His challenger, Bill Nelson, has spoke about the issue on the Senate floor last week, basically hammering Rick Scott and the Republican AG of the state. So I think that there's no question that this is really an issue that you can explore in your state no matter what. You already have Republican Attorney General candidates criticizing California Attorney General for his aggressive defense of the ACA. So these tensions are there and playing out right now, and frankly, I think it's only going to escalate, especially with some of the dates that are coming up, for example, around July 9th in the litigation. You can go to the next slide. So I think one of sort of the things that we look at in terms of kind of what we know and what we don't know. What I mentioned earlier, that this lawsuit was kind of largely played did the Republicans in Congress have any sense that this could potentially happen when they supported the individual mandate repeal as part of the tax plan? Keeping a close eye on whether there'll be sort of legislation along these lines, especially because of Congress staying in session in August, will be really important to keep an eye on, because that even could potentially trickle down to states and what state representatives and senators are doing. Next slide. And I do think I've heard, I don't know if this is going to happen, but some of the Democrats I've talked with, at least the Hill staff, were saying, is there a chance we could file a lawsuit in a more friendly venue? I don't necessarily think that will happen, but I think keeping an eye on what Democrats may do in response is really important. And I also think one really interesting thing to explore, and you could explore this even at the state level, is Democrats have kind of been torn over how far to go on their single payer argument and Medicare for all, especially in areas that are more conservative, maybe where Trump won. But the sense is that this concern about these provisions in the ACA and the lawsuit is that may actually prompt more Democrats to kind of embrace the idea of saying we need to not just fix the ACA because it's so vulnerable to attacks and Republicans are so tenacious. This is something that is only getting harder, that you could focus, that they're focusing more and more on Medicare for all, and looking at whether this lawsuit is going to get more Democrats to go that route, and also what impact this will have on the next open enrollment. If people feel like the law itself is kind of insecure, what will that do on open enrollment? Frankly, I don't think it's shown a huge effect so far, because there's been other times where we just haven't known what was going to happen. There still seems to be steady demand, but I think it's a question, and people don't always understand what's going on beyond the headlines. So those are kind of my thoughts about this book from a reporter covering this, and from the point of view of what other reporters out there could look into. I do think that there's no way of getting around the fact that, in DC, healthcare might not always be the big thing these days, but out there, when you go out and talk to people, when you look at the polls, people really care about healthcare. And this, if nothing else, is going to get them even more wound up or interested, whether it be, Republican voters who are really eager to see more chopping away at the ACA, or Democrats who see this as something that they need to get more zealous about in their efforts to protect it. So it's ripe for so many stories on so many levels at both the local, state, and national.
Well, I want to thank both of our panelists for these excellent presentations. We're going to open it up right now to your questions from the audience. We've received a number already, but there's a couple hundred of you. If you use area in your, try to ask as many questions as we can. Journalist Virginia Anderson, who says, beyond patients Who stands to lose the most? Hospitals, and have any stakeholder groups created financially?
The Medical Treatment and Active Labor Act, they have to treat people with urgency or not. And they definitely filed a brief in the case, very supportive of the Affordable Care Act. I am not sure whether that brief quantified the amount that they have to lose in reports in recent months of how much uncompensated care has been cut under the Affordable Care Act. The health economist's brief has observations and evidence of that.
I would agree on the hospital side in terms of their uncompensated care, and I think you're even from the local level talking to hospitals about this could make sense. They are, very concerned about the potential cost should this be another issue, especially hospitals that treat a large number already of people who have don't have insurance.
Comment from Stephen Goldberg sharing for your commentary. He says, remember that pre-existing conditions include issues that the administration wants treatment for, like opioids, behavioral health, PTSD, that all need multi-year treatment. So what would happen to those initiatives?
Well, go ahead.
Go ahead, Stephanie.
I think that the Trump administration would still push for its initiatives of coverage for opioid and mental health treatment. But if insurers, should this go ahead, would still be able to deny people based on pre-existing conditions. So it does set up a potential conflict, I would see that way.
One thing also I think it's important to remember is that the Texas lawsuit itself is aimed at not just invalidating the guaranteed issue community rating pre-existing condition provisions, but the entire and for example, funding of community health centers. It would take down funding of the Medicaid expansion. It would take down funding of, the Medicare program, and the Community Prevention and Public Health Fund, which has been a major source of funding for treatment of some of these problems. So the scope of the relief asked for by the Texas brief is just so sweeping that it's inconceivable. But I think that, in a sense, makes the Justice Department's brief all that more dangerous, because Judge O'Connor, I think, could say, well, I denied them most of what they wanted. I just gave them a little bit. But that little bit would be basically enough to destroy the individual insurance market with a lot of run-on effects.
We have a question from Mark Miller, who says, if protections for pre-existing conditions fall, what would be the implications for Medicare from a cost perspective? And he hypothesizes that this could translate into higher numbers of uninsured, sick, and untreated enrollees arriving at Medicare eligibility age.
Well, I think that certainly an effect on the health of people entering the Medicare population. But again, just remember that if Texas gets the relief that it wants, I think that since they asked to enjoin every regulation written under the Affordable Care Act, the Medicare payment regulations, the Medicare Advantage payment regulations were written in part under the Affordable Care Act, so presumably they would be dated, and hospitals, Medicare Advantage plans could not be paid by the federal government until new regulations were drafted. So it's just a very dangerous lawsuit. One other factor is that Medicare does in fact reimburse hospitals for uncompensated care. So if we have a lot more people who are uninsured, that's going to be a cost that will be taken on by the Medicare program as well.
And we have a question from Elena Marino, and maybe you could comment on both her interpretation of the data as well as her kind of question commentary. She says that the number of small businesses offering coverage has declined dramatically, and and that the number of large employers has not offering coverage has not changed. And she hypothesizes that this is because small businesses feel they have less choice under the ACA for what they want to offer employers with this essential benefits idea, and that more might sign up if the ACA were pretty much undermined through this lawsuit. So I'd welcome your perspectives on that.
Well, the small business coverage has been in a steady decline for a couple of decades now. The small business insurance rates have in fact been going up more slowly since than individual insurance rates, and also some small businesses have gotten tax credits to under the Affordable Care Act to help them pay for health insurance. I would encourage people to look at the Small Business Majority Brief, which does have a lot of information on what's been happening with the small group market under the Affordable Care Act. But I think one factor is that that groups that used to struggle to get coverage under the small group provisions are now covered under either the individual insurance market because they can get subsidies there, or under Medicaid. A lot of employees of small businesses have been covered under the Medicaid expansion. So I can't say exactly what's been happening in that market. And certainly, I mean, the Affordable Care Act did eliminate a lot of mini-med plans that looked like coverage, but in fact offered very little protection at all. And I'm sure that some of those have been dropped. But I think it's just a very complex picture. And I, again, would encourage people to look at the Small Business Majority Brief for more.
With the association health plan rule that is coming out. But I do think if you look at the Kaiser data, yes, there has been a drop in coverage among small employers, but Jost is right. It's actually been the cost for small employers has been going up for some time. I also think you have to ask yourself, just from devil's advocate point of view, even if more small employers were to offer coverage, what would the quality of that coverage be? What benefits would be offered there? It's a decent question, but that's what's interesting about this lawsuit is that there really are so many unknowns when you try and look back at going back to pre-ACA, but you're also talking about that unwinding process. So I think any impact from something like that would be quite a ways away still.
And Tim, we have a final question for you. There's a lot of talk about Congress introducing a new conservative healthcare reform plan as this effort to undermine the ACA takes place. Is that something that's been inspired by these latest developments with the lawsuit? And what can we anticipate and what stories might be there?
That's a good question.
Well,
I'll jump into it, Jost. I think that the plan that's being pushed by the conservative groups will probably be out this week. And I think it will largely build on legislation that was initiated last year the Graham-Cassidy bill that would look at, giving the ACA money and turning it over to the states in the form of block grants, is at least the rumors that I'm hearing. But this was something that's been underway for 9 months. It's something they've been meeting weekly on for 9 months. And honestly, I'd be hard-pressed to see it get much traction on the Hill, because Mitch McConnell has said he really doesn't want to bring anything up unless it has the votes. And the votes really are not there. Many moderate Republicans want to move on. But I think it's yet another example for Democrats of the increasing attacks that are happening. And this lawsuit adds to sort of that feeling of the precariousness of the health law when they're out there talking about it on the campaign trail.
And as I said earlier, I suspect that part of the agenda of the Trump administration in filing this brief was the hope that it would force repeal efforts back onto the congressional agenda. And certainly if Judge O'Connor rules for the Trump administration, I think there's going to be a lot of pressure from the administration to say to Congress, okay, well, we've got a big mess here without pre-existing condition and protections, and you've got to do something dramatic to fix it. So I'd say watch for that.
I also think one other thing to watch, just to throw this in really quickly, is I have also talked to some Republicans who are talking about doing something legislatively to further safeguard pre-existing conditions. Now, frankly, I'm going to be surprised if that happens, but the fact that I'm talking to House Republicans who are saying that is really interesting to me.
Maybe just one sort of comic note on the case is that very early on, some individual filed a motion to intervene into the case, asking the court to order John McCain to vote for repeal. And that person just keeps coming back over and over again, even though everybody else is.
Well, on that note, I want to thank our distinguished panelists for their excellent commentary, and to thank all of you for participating. We're going to end our webinar. Shortly, we'll be sending you a brief questionnaire where we ask you for your feedback on this webinar and your ideas for future ones. Please take a moment to fill that out. And I wanted to let everybody know that the webinar video will be available along with all the PowerPoints and resources on centerforhealthjournalism.org, and you'll be getting an email about that as soon as it's up. Thank you again, and have a good day.
Thank you.
Thanks.